The Executor and Administration Guide. Continuing on page 78. To the adjustment of the claim, Barhurst versus Hunt, 16 How 407. The executor or administrator may require by law satisfactory vouchers in support of any claim presented under this notice, such as copies of papers on which it is founded, and also an affidavit, see Form Appendix, of the claimant that the claim is justly due, that no payments have been made thereon, and that there are no assets against the same, unless stated in the account to the knowledge of the claimant. If the executor or administrator doubt the justice of any such claim so presented, he should expressly reject it, putting his rejection on the ground that the claim or some part of it is not legally due. Kidd versus Chapman, 2 Bob Channel, chapter 414. And he may enter into the agreement with the claimant to refer the matter of controversy to one or more disinterested person to be approved. Agreement or be approved. I'm gonna fuck out where I'm at now. Where I'm at. We'll start right here. Agreement or approval of a surrogate in the office of the county clerk. The matter will proceed as action in the Supreme Court, and the report of the referee may be appealed from as the similar proceeding begun in the court. And if the claim be disputed and rejected by him, and is not referred as above, the claimant will be barred from commencing a suit against the executor and administrator unless he commence the same within 6 months from such dispute or rejection, or within 6 months after the same or some part of the became due, and the executor and administrator may prove the facts of such refusal, and elect commence the suit within 6 months in bar of the action begun afterward. Matter of East of Alexander Roder Brad 192 Whitmore versus Fuzzy 110 159 Ronald versus Collins 3 Hill 36. To protect the executor and administrator from a cost, he should accompany his rejection of the claim with an offer to refer it. Where we at? Rejection of the claim with offer to refer it. The offer need not to be writing. Lansing versus Swats 9 How 434, and where the parties cannot agree upon the referee and referees, it seems that the offer should be to refer to one or more of the proof by the surrogate. Garham versus Ripley 16 How 313, where the executor, when the claim was presented, rejected it, but afterwards entertained negotiation in reference to the settlement. In what it was held that his previous rejected it, but afterwards entertained negotiation in reference to the settlement. It was held that his previous rejection was waived, and the statutory bar to the action could not be interposed. Garland versus McLaren 47 bar 206. In case of any suit shall be brought upon a claim which shall not have been presented to the executive administrator within 6 months from the first publication of advertisement, he will be protected in having made payment legacies, or any debt or distribution among the next of kin. Before such suit was commenced on proving such advertisement, but any creditor who may have neglected to present his claim under the notice may notwithstanding, collect in the next of kin in legatees who may have received assets from the estate. No executor or administrator shall be charged able upon any special promise to answer in damages or to pay the debts of testators or intestate out of his own estate unless the agreement for that purpose or some memorandum or note thereof be in writing, expressing a consideration and signed by such executive administrator or by some other person by him thereunto specially authorized. 2 RS 113, 3 RS 5th edition 201. Liability of the executor, obligations, contract by him. The question as to who is liable for obligations contract by the executor administrator has been settled in Ferris versus Merrick, 41 New York 315, which holds that the executor administrator is liable personally and not the estate for contracts made for the funeral expenses of the deceased, and that all causes of action arise upon the contracts made by executors or administrators are against them personally and not against the estate. And the judgment must be de bonis pauperis, that is, against his own goods, and not the goods of the estate. Such cause of action cannot be united with cause of action arising upon the contracts of the deceased. Of the payment of debts and legatees. At the expiration of the 1 year from the issuing of letters of the executive administrator in presuming to know not only the assets in hand, but having advertised for claims, also the liabilities in the state, and he may proceed to pay debts, legacies, and distribute among the next of kin. Legacies are directed by law to be paid in 1 year from the granting of letters, unless by the will an early or different time is fixed. But debts are in all cases to be paid in preference to legacies. 27 2 RS 87 3 RS 5th edition 74. Every executive administrator shall proceed with diligence to pay the debts of the deceased, and shall pay the same according to the following order of classes: debts entitled to the preference under the laws of the United States, taxes as assets upon the estate of the deceased previous to his death, taxes, assets, and real estate subsequently to the death of the deceased are not to be paid by the executive administrator. Wilcox versus Smith, 26 bar 316. An assessment confirmed at the time a testator is deceased, although a lien upon the real estate is also a debt to be paid out of the personal estate. Seabury versus Bowen, 3 Brand 207. Judgment, docket, and decrease enroll against the deceased according to the priority thereof, respectively. All recognizances, bonds, sealed instruments, notes, bills, unliquidated demands, and accounts, or in other words, all other debts. Mortgages cannot be paid out of the personal estate unless such payment is provided for the will. Real drawn versus real drawn, Forward Brand 114. But where the real estate and personal estate are thrown into one fund, in which the same parties are interested equally, the executor may, for the benefit of the estate, apply personal property to pay a mortgage on the realty. Hepburn versus Hepburn, 2 Brand 47. In the case of unpaid money of the real estate agreed to be paid by the ancestor and testator. The heir or the devisee has the right to have the same paid out of the personal estate of the decedent. Wright versus Holbrook, 32, New York, 587. Where the creditor has additional security, he should be compelled and exhaust the security and only come in against a personal estate for the deficiency. Halsey versus Reed, 9 page 446. The creditors of the insolvent firm in case of death. Stop right here.